On the phone, it is a pleasure to welcome to the program contributing writer to The Nation magazine, contributing editor to In These Times, and co-host of the podcast Belabored, Michelle Chen. Michelle, welcome to the program.
Hi.
So, Michelle, let's talk about we've covered, I think, quite a bit, the Harris V Quinn ruling that the Supreme Court handed down last week, or I guess it was 2 weeks ago now, which involved the question as to whether or not fair share fees, the fees that union members are required to pay, or I should say, the fees that people who work in more or less a union shop, whether or not they're members of a union, are required to pay just for the expenses of the union negotiating their contract. And we've spoken about how the Supreme Court is en route to determining this for a broader class of people. But this was specifically for a specific subset of union members who the Supreme Court is now deemed, public union members, who the Supreme Court is now deemed are not eligible. Just tell us about the general subset, and then we'll talk about who exactly these folks are.
Right. Well, the case basically took on a Supreme Court precedent called Abood versus Detroit Department of Education, and it's a 40-year-old precedent that basically says it mandates. It mandates fair share for public sector unions because they say that just like workers in the private sector, if they're represented by a union that's collectively bargaining on their behalf, then it's their duty, it's their fair share to basically pay for the maintenance of that union, of that organizational structure. So the subset is public sector workers. So these are people like teachers, cops, firefighters, things like that. But the Supreme Court really zeroed in on a subset of these unionized workers, and they basically looked at home health care aides in Illinois, so a subset of a subset of a subset, if you will. But in Illinois, there is a group of a rather large group, tens of thousands actually, of home health care providers who basically act as health aides for people with disabilities. So they care for them in their home, and it's a system that was set up as sort of a way to merge the idea of community-based personalized care for people with disabilities and the idea of like a Medicaid-funded public structure for providing health care. And the point was basically to sort of deinstitutionalize care for people with disabilities. And so these home health aides, they have been doing this work for many, many years, and it was about 10 years ago that they got a union finally. And since then, SEIU has managed to collectively bargain on behalf of home care workers across the state, and that's led to substantial gains in terms of wages, benefits, training, and such. So this case was then brought by, ostensibly the plaintiffs were a group of workers within that subset who objected to the idea of fair share, right? So they personally rejected, they're part of a group that voted against unionization, and they thought, look, this is not fair. We're personally not in favor of a union. Why should we have to pay these fees, right? And what happened was they sort of used that argument became sort of a cudgel for the right to work movement, which I think you've probably talked about in your show quite a bit in terms of just this movement around the country that has been trying to overturn things like fair share and undermine union rights across the country. And so they look for every single sort of loophole in the law that they can exploit. And so they took this case to the Supreme Court and they basically said, look, these workers are being treated unfairly. It's what they call forced unionization, as if like someone's holding a gun to their head and saying, you must pay dues to this evil union. And that's how it wound up at the Supreme Court. The Supreme Court basically ruled that, the workers had a right to not pay. And that is essentially kind of unraveling this collective bargaining structure, or it threatens to unravel this collective bargaining structure. In my article, I talked about why this is particularly relevant for the group of workers at the center of this case, because they aren't just regular public sector workers. They are particularly precarious and sort of unique set of public sector workers who work in the field of care.
Now, Michelle, let me just clarify one thing. The ruling held that ultimately they were not required to pay fair share fees because they were not actually the court didn't ultimately consider them public workers.
Well,
is that right or no?
Yeah, I mean, they created sort of a carve-out. So Samuel Alito, in this rather unique phraseology, came up with the term a partial public employee. So basically, they said they're not really public sector employees, so that earlier precedent doesn't really apply to this group of workers. And the justification he used was what I was getting at earlier, which was that these are workers who work in the private homes of individuals, and so they're much more like private sector workers than ordinary, say, like people working in, collecting tolls at a toll booth or meat inspection or something like that. So essentially, he's saying these are kind of quasi-public workers. And so by creating this carve-out, they basically undermine the precedent for these home care workers. And what this does to this group of workers is it takes a sector that has been historically very precarious, really low wage, extremely arduous working conditions, often exploitative, and it's going to impact disproportionately women and women of color, especially. These are jobs that have historically been done by women of color and immigrants, and that's been consistent, for well over a century now. And those are the groups of workers that are potentially affected by this. And I argue that union rights are the fact that they're being carved out really shows just how marginal they are in the workforce. And even though they had this union, right, it's now come under attack from the highest court in the land. And you still see this persistent kind of ideological thread saying that they don't count because they're doing women's work.
Yeah, I want to get to that angle of it, and just so that people are clear, the deal was struck between the SEIU and the state of Illinois because these workers are being paid out of Medicaid funds, which of course are public sector funds, and so what happens now? I mean, so you have the opportunity for these workers to essentially opt out for paying their fair share of the fees that are involved specifically in the negotiation and the development of these contracts, and I would also imagine sort of the oversight in making sure that people are getting paid what they're supposed to, that the working conditions are up to a specific standard. So how is the union reacting to this? I mean, do we know? Has there been enough time yet?
Well, from what I understand, and I've done a little poking around in terms of what people in the labor movement have been saying, and also some scholars who study this stuff. I mean, they say that it wasn't as big a blow as it could have been for a couple reasons. First of all, it only affects, one portion of the public sector. So their, fair share still applies to many other public sector unions out there. But another thing is that people think that this is going to be sort of a good, kick in the behind for the labor movement, that it might actually re-energize some of those organizing efforts and perhaps goad established unions into not taking their dues paying workers for granted. So they're saying maybe this will revitalize organizing efforts at the grassroots level, and so they'll start to undertake, really intense membership drives. I mean, that's one possible reaction. Unions could say, look, now that workers are no longer mandated, right, to pay for the maintenance of the union, we have to sell ourselves, essentially. We have to market ourselves. We have to give them more of an offering in terms of what we do to represent them. And so this might mean, making stronger collective bargaining demands, representing them politically in another way, using their union apparatus to do more political mobilizing and rally people around a cause, or even just doing membership drives themselves. I mean, SEIU, since this ruling was handed down, they've continued with their organizing efforts. I think they are currently in the process of organizing a home care workers union in Minnesota, and the workers there, they're like, yeah, this is a setback, sort of on the legal kind of theoretical level, but we're just going to keep on plowing ahead. And so they're reaching out to more workers, and they're trying to make the case for why you should pay your dues voluntarily.
And there seems to me, at least from a very sort of practical standpoint, a fairly good argument when you look at the difference it's meant just in terms of pay. Walk us through those numbers and give us a sense too of what the other implications are in terms of working conditions. And I know there was also a sense that having a union basically provided, in all that entails, provided a sense that people, and like you, and the point of your piece, that the women who are in this profession are in fact in a profession.
Yeah, definitely. Just in general, looking at the way women benefit from unions, there have been a couple of reports that I cite in the article. One is from Center for Economic and Policy Research and Economic Policy Institute have both done studies on this, but they've shown that there's actually a pretty significant union advantage, and it is unique. And there's a union advantage generally for workers, right? If you're part of a union, you're more likely to have better wages and benefits. Period. But for women, especially, they might earn, somewhere between like 13 and 16% higher than their non-union counterparts, right? All other things being equal. There is a significant gain in things like, job security. They get paid sick days. They get more generous family leave policies, for instance. It matters a lot when you're in a really tough, intense profession like home health care, when you're basically might be on call like 24/7, right? To have those days off. And of course, if you're a healthcare worker, you don't want to go to work sick, right? So having paid leave time is really important. Having things like pregnancy leave, right? Those are all things that are vital to working women, and they're especially rare for women who are doing low-wage service work in the care industries like these women. I mean, the gulf is even greater when you're looking at home health care, because this is where benefits like that really matter. Because if you look at a lot of home health aides across the country that are, working for private agencies, or they're just independent contractors, they might be even in a worse situation than like domestic workers who may not have like the same kind of medical responsibilities, right? Because for a very long time they were specifically carved out of federal labor protections. So under the Fair Labor Standards Act, it wasn't until recently that they even qualified for things like overtime, right? Recently, the Obama administration changed that rule, but it was only because activists were very active in pushing for it. But overall, I mean, unionization, absent, things like dramatic increases in the minimum wage and, big legislative changes, unions are a crucial backstop for a lot of women, and they are often their only representative. I mean, think about it. If you're basically laboring in someone's private home all day, I mean, it's just you and like basically the person who's supervising you, right? The patient you're caring for. There's no one else there to represent you. There's no shop floor, right? Rules are hard to enforce. And when you have a union behind you, then you have some measure of accountability. And yeah, like you said, I mean, there's an institutionalization of your profession.
And so what is being done? I mean, it's interesting because I think, and we've spent a decent amount of time talking in the past in this program to representatives of teacher unions, particularly ones like in Chicago and Massachusetts, where they're starting to perceive. They're starting to follow a more of a social justice unionism model as opposed to like a business unionism model. And it seems to me that in this profession, not unlike the teaching profession, that there's an opportunity for the union to build relationships, strategic relationships with patient advocacy groups, because it's quite clear that not only do the caregivers benefit from being represented by a union and having all of the sort of standards and practices and mechanisms for accountability from their work perspective, but I would also imagine patients across the board too benefit because now they get better home care providers.
That's right.
And so is there a move? Has the union indicated that there's going to be a move to try and build relationships with advocates for those home care patients?
Yeah, I mean, they've already done that in large part. In fact, I mean, when they were first fighting for a union in the first place, right? During their first initial push for a union, they reached out a lot to communities. They went to the client community. They went to people with disabilities who were already receiving care, and they said, look, this is an arrangement that's going to benefit both of us, right? And people who need this care at home, they understand how crucial it is to have like things like standards, right? Things like adequate rest time for the person who's, providing you with critical medical care, right? Often in the privacy of your own home when you don't have access to any other immediate medical help, right? And actually, there were groups, in the amicus briefs, you can actually find the voices of, the disability rights community saying that, look, don't take the union away. And what's ironic about that is that Alito tried to sort of drive a wedge through that argument, right, by saying, oh, it's, the clients are actually, the consumers of the care, they're actually their bosses, right? They tried to create that sort of, they had to try to sort of triangulate between them, and what these consumers are saying is that, well, we actually favor unionization because what's good for our workers is good for the quality of our care. I mean, look, their collective bargaining agreement includes things like, training, right? I mean, that's critical, obviously, for people who are doing healthcare at home, and that wouldn't be guaranteed. There wouldn't be a baseline for the quality of that training or the quality of those professional services, without some form of collective agreement. And I think that's why the state also, which is the technical employer of record here, the state was also in favor of the union. So you actually have this curious sort of arrangement where you have the bosses, so-called, who actually understand this is a critical public service these women are providing, and unionization is good for them and for us. And that's continued in their advocacy.
Do we have a sense of just how many workers? I mean, obviously, this is this case applies to whatever Sam Alito's favorite phrasing was, these partial public workers. I mean, how many of these exist in states to states, and are we already seeing sort of the implications on the other contracts that states may have with these groups of workers? And I mean, in other words, the fallout from this, it obviously is larger than just Illinois.
Right. Well, I mean, I do want to stress that nothing in this ruling is going to change their fundamental right to form a union, right? That is protected. So, in terms of just like the their contracts and things like that. I mean, that those exist, right? The issue now is how well is the union going to be able to support itself financially if you might have the dues payers population kind of eroded by this lack of the fair share protection. So it'll be a while before we see some of the financial fallout from this. But right now we actually see more and more states coming on board. I mean, started with California, Illinois, now Oregon, Washington, Massachusetts, Missouri have all, had come out in favor of collective bargaining for their home care workforces. And, in a way, by making them all public employees, it gives them a little bit of an advantage in terms of just, all of a sudden the union is able to add 20, 30,000 members, right? In a single election, or is able to increase, their collective bargaining representation by that much. So, it's going to be a rockier road ahead, but nothing changes the fundamental rights or the fundamental structure of collective bargaining. And I think that's going to be one of the things that unions are going to really have to sell, right, to workers.
Let me ask you this question too, and I haven't really been able to get an answer for it. I'm not sure that you'll be able to do this, but why wasn't this a determination that is left to the National Labor Relations Board under the National Labor Act? In other words, I know that in the context, I mean, every day, every week, I don't know what the National Labor Relations Board goes in and makes the determination of whether or not a group of people qualifies to have a union. For instance, in New York, I know that there was a question. It actually garnered a little bit of attention because some MSNBC hosts were dragged into this, but there was a question as to whether or not one production entity owned by NBC, whether or not their writer, producer types, director types were considered eligible to form a union, as to whether or not they were management or not management. In this instance, it's obviously it's not exactly analogous, although it seems to me if the Supreme Court made their decision based upon whether or not they qualified as being public employees, as opposed to partial public employees, why wasn't that a determination for the National Labor Relations Board?
I think it has to do with, I mean, the thing is, like, they're deemed public employees simply by virtue of the fact that they are on the state payroll, right? I mean, they're in the employ of the state. What Alito did sort of creatively here is that he created like a subclass of public employees, which kind of deemed them quasi public workers. And so, I mean, I don't know exactly the sort of rationale behind the jurisprudence, but I imagine this is not really a determination for the National Labor Relations Board to determine, because I think they do things that are more just upholding existing law. And this was originally determined, the agency shop thing and fair share for public sector unions. Those are basically just court precedents that apply to all public sector workers, and so how they're designated is kind of just depending on who their employer is. In terms of just like the right that they have to charge a service charge to all members of a collective bargaining unit, that was actually established in court precedent. And so it's left up to the Supreme Court to either uphold or overturn that precedent. But, anything deeper than that, you'll probably have to get a lawyer. So.
All right. Well, I have a bunch on my speed dial, but I'll work on it. But Michelle Chen, thank you so much for your time contributing to the Nation magazine, contributing editor in these times, and the co-host with Sarah Jaffe of the podcast Belabored. And where can people find that on iTunes, or is that over at Dissent?
Yes, it's on iTunes, it's on Stitcher, and it's also on the Dissent website, so dissentmagazine.org.
All right, Michelle Chen, thank you so much for your time.